You say you haven't been the same since you had your little crash, but you might feel better if they gave you some cash. The more I think about it, old Billy was right. Let's kill all the lawyers, kill them tonight. You don't want to.
Wish I was up on Rocky Top. Hey man, oh my goodness, you tripped. That's a good little segue.
There you go.
This is another episode of Two Marks and
One mic, or two marks, one mic, and we want to talk a little bit today about a case.
Let me remind everybody, every month we get this Tennessee jury verdict reporter.
Right.
And we just love to go through it because it reports jury decisions, and of course that assists us in what a jury's going to bring back on a case, and the damages and the award of the jury. So it's very informative as far as we're concerned, because the jury reporter is full of cases that we are in the office right now, and there's one that I saw. John Mark has another one that's also even a better case. But our case today we're going to talk about involved a Walmart right here in Chattanooga. Right here in Chattanooga.
It's a local plaintiff's lawyer who we've known for years and years and years, a while hour long.
Good job, and he got a great verdict. Hour long, well done on this one, because Walmart wouldn't settle. I mean, there's some reference in here, John Mark, in the reporter that where admission was made before the lawsuit, and somehow I don't know whether or not it's just for this article, but Walmart admitted to not providing a reasonably safe place for you to shop. Walmart said this. They admitted that.
And
did it matter? No, they didn't.
A little bit of the facts for this is in the parking lot out in front of Walmart, in an area where the handicapped cars would typically park. There was a signpost that stuck up out of the asphalt.
A handicapped parking signpost, right?
Yeah. So all that was there was the very bottom of the signpost, where it had been cut off, or they'd been hit by a car, or Walmart decided to remove it, or whatever the case may have been. But there was a part of a signpost that protruded from the asphalt a couple of inches.
2.5 inches right there.
That
stuck up out of the asphalt.
That created what we call as a trap.
Yeah, trap.
A trap is something that we call is a defect in the property that the premises owner or occupier knew or should know about.
Right.
Failed to take measures to address it, and it becomes a trip hazard because clients can't see it, or it's hard to determine what that trip hazard may be. But in this case,
just to review, just because you fall down at a Walmart does not mean that Walmart is responsible for your injuries.
That's
okay,
correct.
You have to demonstrate that Walmart knew or should have known about the hazard well enough to be held liable for your injuries. And I have won cases and lost cases based upon the security I've won cases and not taken cases on the basis of the security cameras. For example, security camera, mommy, this is the case. Mommy, of course, client came in, broken kneecap, because she slipped in what appeared to be, ice cream. In an aisle, came around the corner, fell, damages, good damages case, so I did look into it, but Walmart, of course, if they have a video that's going to absolve them of liability, they're going to show it to you right away, which is a good thing, because I kind of want to advise my client right away whether or not this is a good case or not on liability, and their cameras are throughout the store. And what happened in this case, mommy, baby and buggy, baby drops a piece of soft yogurt on the floor. Within 5 seconds, my client rounds the corner, slips, breaks her knee. Now, that's not enough time to hold Walmart responsible.
Because Walmart has to be able to know or should know. In other words, they see it happen and need to take steps, or
it's been there long enough.
They should know if they were taking reasonable steps to identify these things, and something that happens quick like that, it's just not a case. Walmart should not be held accountable in a situation.
Well, and then if I don't get a video from Walmart when I do my demand letter, then that tells me they have a video that's not good for them, and I eventually get it in discovery, and I notice a different case where there's soft yogurt in the aisle for an hour and a half, where Walmart employees are walking up and down.
Well, the prime example of another Walmart case was similar substance on the floor that'd been on the floor for not a long duration of time, but long enough they should have known, because Mark, this was the case where there was the yogurt or substance that was right in front of the cashier stands.
Yeah, okay.
And they kept saying it wasn't on the floor, but more than 15 minutes or whatever they were saying. Said,
right.
yeah, but you have a cashier standing right there looking
Right.
at it. Walmart's got some procedures they follow.
Right.
If
Right.
somebody
Yes.
identifies it,
Right.
the employee goes and stands in the area where the substance is. They call cleaning to come out there. They
Right.
mark it.
Abs-
But in this particular case, it was ignored. But
Props to Walmart. Props to Walmart. You're exactly right. When they see a substance, they have a speedy response team. They have mop setups. Every 2 or 3 aisles. They have wide aisles where you go into a cheap Dollar Tree or a Dollar General. You just notice the difference between the Walmart layout and the Dollar General layout. Walmart stocks product, in off hours. Dollar General stocks products through busy hours. I mean, seriously.
It
Walmart
doesn't mean that Walmart doesn't do things wrong.
Yeah.
They do. But here's the thing. Not just Walmart, but any premises that has security cameras, we like that.
Yes.
We want to
Yes.
know
Right.
whether or not
And-
there's a viable case or not a viable. We want to know off the bat. And if Walmart or any other should not be held accountable for something that's on the floor because they haven't been there long enough,
Yeah.
we want to know now because we don't want to be involved in that case.
And in this case, we started talking about has security footage in the parking lot area, has her tripping on the thing that stuck up 2 inches. She broke her pelvis in 2 places and also suffered a broken shoulder. Broke her pelvis in 2, that's a significant injury. Pelvis in 2 places, broken shoulder. And the defense of Walmart was that there was an interloper. An interloper came in and wanted a souvenir. So they decided to actually, this is a metal sign, okay? And somebody wanted the souvenir of a handicap sign. I guess they just went back and forth.
Well,
back
Walmart
and forth,
said,
back and forth.
Walmart says it got chopped down. I
Chopped,
think is what
okay.
they said.
Chopped down.
I'm not really
Now,
sure
now,
chopped down a metal pole.
They have security camera to show her falling. You would think they have some kind of security footage to show some interloper with a hacksaw out there wanting this, this souvenir. See, I really think sometimes juries, sometimes defense lawyers don't appreciate juries about how they can, reason through all this and get to that's a stupid defense. That's going to piss off a jury. And an interloper came in. Well, we're not responsible for that. An interloper came in, sawed it off, and we don't know when it was sawed off, how long it was there.
If you look at the photograph of the stub of the sign, it clearly wasn't sawed.
No, it wasn't.
But anyway, the
jury came back with $500,000. However, they attributed 30% of the fault to the plaintiff, right? And how does that work, John Mark, as far as the 30%?
So in Tennessee, what we have is comparative fault. So you compare the fault of the parties to one another. If there's more than 2 defendants, more than 3 defendants, or more than one plaintiff, you compare the fault.
Yeah.
And in this particular case, there was Walmart was one defendant. The lady that fell was the plaintiff. So they apportioned it 30% to the plaintiff.
I guess
70% to
Right.
to Walmart. So when the jury arrives at the $500,000 damages, that's 100%.
Yeah, right.
And so it would mean that the plaintiff, since they're less than 50% at fault, would be entitled to that remaining percentage, which would be 70% of the $500,000 or $350,000.
Exactly. So I guess the jury found that the person should have been watching where you're stepping, and that's always going to be brought up in a premises liability case. Look where you step, and the jury found that the plaintiff should have been looking where she was stepping, even though, that I don't see how you see that thing anyway in this trap in the parking lot. But interesting case, big verdict. Way to go, Wild and Wild. Ira, great job. Keep it up. The other case that we flagged in this month's jury reporter is a case. Honestly, guys, I mean,
it's a case where there was little visible damage to the rear of the vehicle.
This case was so bad, and really, kudos to the plaintiff lawyer. He worked some magic on this one. This one happened, I think, in Nashville. Was it? Was it Nashville or someplace?
Yes, Middle Tennessee.
John Griffith is his name, not John Mark Griffin, but John Griffith, and he is a great trial lawyer. Not as great as John Mark, but still a great trial lawyer. And this case, we have this case had fleas. I mean, this is a dog case from the word get-go. First off, not very much property damage in the rear end of this van, which really, in my mind, I mean, cars are designed nowadays to really put the brunt of the impact on the occupants, and so property damage to me is NASCAR cars explode, drivers walk away. But I have seen significant injuries with very minimal property damage shown, just because the way the undercarriage might be bent. But really, the cars are designed not to show a lot of property
Well, the bumpers
damage.
are designed for bumpers to
Yes,
hit, so
exactly.
you're still transferring the energy from one car
Right,
to another,
right.
which can result in injury. But oftentimes with the plastic bumpers, damage may not be visible, even though the vehicles absorb a tremendous amount of energy.
So this is what we see at a lot of the cases. Not very much property damage. They don't go to the hospital. They refuse medical treatment at the accident scene. That's easily explained. Also, you're so juiced up on adrenaline. You got to go pick up your kids at school. Your car's still drivable. You don't really feel it until maybe the following day or so, after the adrenaline runs off, and your body kind of settles down. Then you have neck pain, and this plaintiff had neck pain. I guess a couple of days later, went to a chiropractor, for the neck pain. So there's no ER treatment right away. Went to a chiropractor, and in this case right here, the chiropractor, honestly, didn't have any kind of medical records. Actually had shredded her medical records by accident, which is just a problem with the case. I'm sure that they just ate the chiropractor alive for shredding the records. But then, not only so strike one, strike two, strike three, bad case, bad case, bad case. She didn't seek treatment for 4 months. 4 months she went to the chiropractor, was fine for 4 months, and then what happens? She is taking down Christmas ornaments and feels her neck pain,
Right.
and then goes to an orthopedic doctor. The orthopedic doctor does an MRI and finds a disc herniation.
Right.
Try to relate. We have to connect the dots here, right? To be successful at court, you have to actually show that the injury was connected to the car wreck. And the further that you have this gap in treatment, the less likely you're going to be able to connect it to the car wreck.
Right.
And
This doctor connected it.
this orthopedic doctor connected it, which we've had cases also where the doctors connect it based upon a medical history.
So here's the moral of the story. There's not, even though you may think a case has fleas,
Right.
or the case may not be a good case,
Right.
or there's not much visible
Yeah.
property damage. All those things we hear from the insurance companies and defense
Right,
attorneys,
right.
while we refer to this as a case with fleas, not all, even case with fleas
Right.
are good cases. And why was this a good case, Mark? What was the outcome of this case?
Well, they got it. I guess they got the medical bills. What,
$71,000 plus
Plus-
another $40,000.
plus $40,000, and this is the well. First, I gotta think that this plaintiff was a good plaintiff.
Absolutely.
Just a great person. The jury had to bond with the plaintiff. So the plaintiff really, in this case, and
Hey,
almost every case.
lawyer did a stellar job.
Yeah,
The
but
thing about this case is
he had a good client, though. I
Yeah,
mean,
good
this
client.
plaintiff was believable. She was credible. She was sympathetic. The jury connected with her, connected with the lawyer, and they got money outside the insurance policy. That's what makes this so sweet, is because they had a $100,000 policy, right? And they could have tendered that policy and just been done with it, and moved their own, merry way. They got hit for outside the policy.
Instead,
And
they subject their insured to an excess verdict,
Yeah.
where now the insured may be responsible for that.
That's what happens.
Again,
happens.
the premises of this is, just because insurance companies and defense attorneys say cases are bad, doesn't, and Mark referred to it earlier when we talk about a case with fleas, those are things that we hear from insurance companies and defense attorneys. What we're saying is, don't listen to that.
Yeah, right,
Don't listen to that.
right.
These cases are good cases,
Yeah,
just
right.
as this case was.
Absolutely.
Now, John Griffith did a heck of a job on this case. May have had a good client, had a doctor that supported, her claims and her injuries, the history that she provided and related this condition.
Right.
So just because there's small property damage, just because there may be a delay in treatment, that does not mean a person's not hurt.
And how often do you hear this, John Mark, where someone says, as involved in a car accident, went to the ER, physical therapy, is this case worth your time?
They're all worth our time.
They're
all worth
I
our
said
time.
that, if you went to our file room, rear ender, ER treatment, physical therapy with insurance, if you went to our file room and pulled out randomly 10 files.
Right.
I would say at least 7 would be that very case, right? I mean,
Yes, and so-
we have the high dollar value cases, you know, where they have to have surgery, blah, 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 you know, but really the bread and butter, you know, what motors this firm, what we're set up for is a case just like this, you know, we have rear ender, not very much property damage, but they have insurance, and you have, you know, a client that got hurt. A client that got hurt.
So the cases that are important to us are the cases that are important to the client. So if you've got a case that has, you know, a small amount of property damage,
Yeah.
small amount of treatment, that case is the most important case that you have, and it's an important case for us as well.
Always will be. This has been Two Marks, and
One mic.
see you next time.